Well, good evening, everyone, and welcome to tonight's webinar, Planning Ahead Estate Planning Workshop. I'm Sandy Irwin. I'm Director of Family Supports at the St. Louis R. So without further ado, I will turn it over to Bhavik Patel.
So today is going to be a discussion around estate planning, and then we're going to interweave components of special needs planning and the importance of why those two things are connected as part of the conversation today. So I'm going to try to share my screen. So just a quick introduction. I'm Bhavik Patel. I am the CEO of a law firm in town, Sandberg Phoenix. And my partner, my law partner, is also going to be on this call with us, Josh Hutkins, primarily because I have a time issue where um, I have to jump off at 7:30 today, and in case there's questions towards the end of today, we want you to be able to ask them, and Josh will jump in and answer some of those questions. So. Um, but like I said, we're going to talk about estate planning and estate planning for families with, in particular, children with disabilities is super important because it's all connected. And hopefully through this presentation, you'll kind of see some of those connections. Um, so I usually kind of start with why. Why do people do an estate plan? And there's a lot of reasons to do them. And I'm going to kind of go through sort of the five sort of biggest ones that I hear the most from families that come and see me. That you see them on the screen right now, but planning for incapacity, avoidance of probate, planning for the proper disposition of your estate, which is a fancy way of saying who gets what, when, who dies when, and how. And then estate tax planning and creditor protection. Those last two, I'm not really going to spend a lot, I'm not going to spend any time really talking about those. I'm going to really pay attention to the first three. And the roadmap for today's discussion is going to be each one of those reasons and what the consequences are if you don't do anything. What happens in the event of no planning? And then what happens or what are your options and what kinds of plans can you do to deal with that particular reason? Then, after I get through that, I am going to talk a little bit about public benefits because no matter what the subject is for this presentation, understanding public benefits is super critical as you connect the need for an estate plan with special needs planning. Let's talk about planning for incapacity. The first thing I want you to know is the general law. And the general law is no adult can make medical or financial decisions for another adult. That's the law. There's no ifs, ands, and buts about it. So that includes married couples. So if I became incapacitated today and I did not have any plan in place, my wife would not be able to make any medical or financial decisions for me. What she would have to do if we didn't have any plan is she would have to actually go to court and become my conservator and become my guardian legally through the court process to then be able to have the legal authority to make medical and financial decisions for me. That's what we're wanting to really avoid because guardianships and conservatorships, that's a process. It's a tedious process, and it's one that we would like to avoid. Most people would like to avoid that. To give you another granular example of the extremeness of this law, my wife and I, we own our house together. We're both on the deed. We both co-own our house. But if I became incapacitated, and again, we didn't have anything put in place, my wife would not be able to do anything with the house, even though she co-owns it, because she has no ability to authorize my approval or my signature on anything that would have to deal with the house. And so that's like the extreme level of what we are talking about that we really want to avoid. So what kinds of things can we do to avoid the need to go to court to get a guardianship or to get a conservatorship? Well, the most simple way, if it can be done, especially if I'm talking to you instead of maybe your child with a disability, is what we call a power of attorney. And there's two types of power of attorney documents. There's a healthcare power of attorney document, which is basically a simple document that names individuals in some kind of order to be able to make your medical and health related decisions if you cannot make those decisions for yourself. Most people would name their spouse and then maybe name other loved ones in your family that are of age to be able to step into my shoes and make my medical and health related decisions. The other document is a financial power of attorney, and that's just like it sounds. It's for everything that's not medical and health related. Who's going to pay my bills? Who's going to access my bank accounts? Who's going to deposit checks, withdraw money? Who's going to sign my tax return? Who's going to deal with the property? Who's going to deal with benefits? Who's going to deal with retirements? Uh, who's going to tell my financial advisor what to do? Anything you do on a day-to-day basis that is not medical and health related, if I become incapacitated, I need someone to be able to do it. And this financial power of attorney document would name, again, in some kind of order, who could do it. A revocable trust is another concept. It's a trust document that says where your assets go, but you title your assets into that trust. And if I become incapacitated, that trust is going to name somebody to oversee that trust. That role is called a trustee. And that trustee would then manage the assets and use those assets for my care, for my benefit. That is a very good tool from a financial side, but it still doesn't address the medical side. That's where the healthcare power of attorney is still needed. And not related to necessarily incapacitation, but there's also a document called the living will, or also known as a directive. This is about end of life decision making. If you truly are at that true end of life scenario and your medical team is concluding that you really aren't viable and that your situation is not reversible, that you don't want to artificially prolong your life. I bring this up because this is a very important document if you want to preserve your assets to not go to unnecessary medical expenses related to your true end of life scenario and preserve them for your family, then you need to be able to give the direction that you don't wish to artificially prolong your life. And then this is not a legal document, but more of a financial strategy. Long-term care and disability insurance. Have you addressed what happens if you become incapacitated when you're still earning wages? Or how are we going to care for you if you need to be in a home um, and need that 24-hour care? These are tools. I'm not a financial advisor, so I'd recommend that you talk to your financial advisor. I'm a lawyer, but these are things we see have profound impact in families' lives if they're in place. But it has to make financial sense for you to do so, and the expense of it, all of those types of things. So I'll stop there real quick and just see if there's any questions. Sandy, I don't know if you
Mhm.
have
Yeah,
questions up
there
there. Or,
is one, and you might get to this. I know you generally touch on this a little bit, but I'll go ahead and read it out. Is it
okay.
possible to save money in an ABLE account towards the purchase of a condo without affecting SSDI payments? Or should we purchase the condo, leave it in the trust for our son, and the trust charges him minimal rent that goes back to the trust?
Yeah, that's definitely a question that will get covered potentially through this conversation, but I'll answer it right now.
Wonderful.
Um, I mean, I think the most ideal direct answer to that question would be mom and dad owning the condo and then charging rent to um, your child with a disability, which I'm going to just reference as Joey for the rest of this conversation. So Joey would be able to live there, pay rent, and you can use the public benefits money, SSI money in particular, to pay for that rent. And mom and dad would still own the home, and then they would get the rent money, and then that rent money would free them up to be able to use that money for whatever they need, whether that be it for Joey to use it for Joey or to use it for anything else the family needs. But that would be ultimately my recommendation, um, without having, a more detailed one-on-one conversation with whoever asked that question, and what they're trying to really accomplish and what their goals are. Then I'm going to move on to the second reason. So this one is the one, probably one of the most popular ones. I people come and see me all the time and they say, "Look, I don't want to go through probate. I don't want administration." Well, first of all, what is probate? Probate is a court process that oversees the passing of a deceased individual's assets to wherever they're going to go. When you don't plan to avoid probate and you go through probate, probate is not a positive experience. Why? Well, it takes a very long time to do probate. On average, an average probate is 12 to 18 months. So that's a lot of time. Well, in addition to the time, and because it takes so much time, it's also very expensive. You have legal expenses, you have administrative expenses, you have courts that are involved in the decisions on what might happen with the assets, and then it's very public. So I've never met any individual that has felt happy that they went through probate. So it's very tedious, and it's not a fun experience for your loved ones that you leave behind if you pass away. But there are lots of ways to avoid probate. Some that don't even involve using an attorney. But every one of these concepts that I'm about to go through, they have pros and cons. So you don't want to take the easiest route. You want to take the right route for you, whatever that might be. But jointly held property. So if mom and dad own property together, mom dies, it goes to dad. Dad dies, it goes to mom. That all avoids probate. If parent child own property together and the parent dies, it goes to the child. It avoids probate. Or if two siblings own property together and one of the siblings passes away, it goes to the other sibling, it avoids probate. So it's a very easy way to avoid probate. Add someone to your account. The downside to it is when you do that, that asset is exposed to the vulnerabilities of what might go on with your co-owner. So if your co-owner gets sued, that asset could be subjected to risk. If your co-owner gets divorced, that asset could be subject to risk. The co-owner could just use the asset in a way that wasn't a way that the two of you agreed. So that could be a problem. And then in particular, if you were going to name Joey as the co-owner, that's going to be a major issue for public benefit eligibility for Joey. So as I try to keep putting in reasons of why estate plans matter with special needs planning, jointly held property is not usually a solution, even though it's an easy way to avoid probate. When it comes to real estate, your home, for example, people can actually record what's called a beneficiary deed, and it operates like a beneficiary designation on your 401k or life insurance. It just applies to the real estate. So I own my home. If I die and I wanted it to go to my children, I could name them as on the beneficiary deed, and when I die, the home would become whoever I named on the beneficiary deed. The problem again is the beneficiary deed can't put any limitations or restrictions or rules around how the recipient is going to treat the home or how it's going to be protected and so on and so forth. And so it's same if it was to go to Joey, you know, it's okay that a home that Joey lives in is in Joey's name for public benefit purposes. But if he has to move, if he has to like go into a home or get some other living arrangements, then that home is going to disqualify him from public benefits if he no longer lives in it. So again, there's some complexities there. Then there's something called a TOD, transfer on death, or POD, pay on death, or just good old fashioned beneficiary designations like on your life insurance, 401k, IRA, things like that. All of that will avoid probate and it will go to the individuals you name. You can't name Joey because if you name Joey and I pass away and Joey now gets whatever I TOD to him or whatever I named him for a beneficiary designation on, then Joey gets it. And if Joey gets assets, that's going to impact his public benefits, which again, I'll kind of talk about when I get to that point. The most comprehensive way to avoid probate is a revocable trust. A revocable trust, think of that as a shoebox where you connect your assets to it, and then the contents of that shoebox go based on the terms of the trust. It could go, it'll say who gets what, when, who dies when, and how. And you can put all kinds of rules to it, and you can put all kinds of contingencies about, depending on the order of death in your family, who gets it and whatnot. And then it also allows you to name people to oversee it and how that money is going to actually be used. Of course, as we're interweaving this with special needs planning, you know, a special needs trust is also assets you put in a special needs trust will avoid probate. But the power of a special needs trust is anything in it for the benefit of Joey is going to not disqualify him from needing public benefits or being eligible for public benefits. This is perhaps the most important part of an estate plan, making sure your wishes, what you want to happen, actually happens. So we call that the planning for the proper disposition of your estate. And if you don't do any planning, here's the big news I want you to know. The state you live in, and I presume most of you live in Missouri, but any state has written an estate plan for you if you choose not to write your own estate plan. And what that state's plan is for you is usually not a good consequence. For anyone that's married, if I die and I didn't have an estate plan, all of my assets get split. Half of it goes to my surviving spouse, and half of it goes to my children, which I'll call Joey and Emily. Well, the problem is if Joey is dependent on public benefits or might be dependent on public benefits, and a half of my half goes to Joey because the other quarter went to Emily, then when Joey gets that inheritance, it's going to disqualify him from public benefits. So that's a problem. That's what the state has written as your estate plan. In addition, if any minor children are going to receive an inheritance, that inheritance, if they're a minor, would have to go through a court process called a conservatorship. And if there's one court process that I can identify is literally the worst possible thing, the hardest, most difficult, most tedious, it's a conservatorship. And the reason for that is the court has to balance the money by the penny year over year over year. And you have to ask the court permission to use any penny you possibly could for Joey or for Emily if they were minor children. In addition to that, the state's estate plan for you says your kids get it. Even if they're adults, they just get it. We've talked about why that's a problem for Joey if he's wanting to get public benefits. But Emily, who doesn't have a disability, she could also get it, and she could just get it, and she would get it outright. And what if Emily was 18, 19, 20 years in college, and she gets all this money? What does that do to her decision making or her motivation or her academic focus? There are things, when you leave an inheritance to your loved ones after you pass away, you want to think about what's the impact, positive and negative, and then really put a plan in place that deals with it. The short answer is think of the world as a blank canvas, and you get to draw your own painting on that canvas. And that canvas is going to answer and do whatever it is you want to do for your family if you pass away with your assets. That's how broad an estate plan can be. And you can do anything you want to do. You can provide for your spouse, surviving spouse. You could provide rules against how your surviving spouse uses the money. So be it. Maybe my wife dies and everything came to me and I had a big gambling problem and I blew it. Or the other way, maybe I just not responsible with money. And so when my wife passes away and I get all this money and I'm just not responsible and I blow it. And you know that about your spouse. So we want to maybe put some rules around it. Maybe name someone else in charge of the money so that they can make those decisions and allow for a distribution to go to my surviving spouse in a way that makes more sense given the circumstance. A lot of times that's not needed, and people just leave it to the spouse and complete control of the spouse, and that's perfectly fine too. And your estate plan can address that too. But one of the things I can tell you is almost 99% of the families that come see me, unless it's a blended family with children from previous marriages, they want the inheritance to go to their surviving spouse and then to the children. Well, that is very different than the 50-50 split that the state of Missouri provides. What about like what I was talking about earlier? Just what kind of some rules do you want to put in place, or what kind of incentives do you want to put into place for your children? And not Joey, for example, but maybe Emily. Maybe we want to make sure Emily graduates from college. So maybe we tie some language in the trust that says Emily doesn't get Emily gets to use the money for her health and education and maintenance and support needs, but she doesn't get more access to the money until she graduates college, or maybe certain ages, so on and so forth. Or if Emily had some kind of addiction problem, maybe we need to put some rules around making sure she is being responsible when she receives her inheritance. And maybe we need a gatekeeper involved to be able to say yes or no to requests that Emily makes. And then for Joey, if we want to have public benefit eligibility at some point, whether now or at some later point in Joey's life, then Joey's share needs to go into a special needs trust. And that's super important to make sure that we don't get disqualified from public benefits. And there's multiple types of special needs trusts. I'll kind of briefly tell you the two broadest types. One is called a third-party special needs trust. That would be if mom and dad, like me and my wife, left money for Joey, and we created a third-party special needs trust for Joey's benefit, and we put assets into it for Joey's purpose. The other kind is what we call a self-settled special needs trust, or also known as a Medicaid payback trust. That would be if Joey ended up getting assets, they're his assets, and we need to get them into a special needs trust. That trust we could put into a Medicaid payback trust, and that trust is going to have a special rule that says when Joey passes away, the state is going to get reimbursed the money that it spent on Joey's behalf during Joey's lifetime. So not a ideal strategy. We would prevent, instead of giving the money to Joey and Joey putting it into a Medicaid payback trust, we would rather give it to Joey in a third party special needs trust. One last thing about third party special needs trust, and I think we might have questions since Sandy popped on,
Yeah.
is there are two types of third party special needs trusts. One is called a testamentary, and another one is called a standalone special needs trust. The difference between those two is when they get activated. So a third party standalone special needs trust would be a special needs trust that I create that's existence is immediate. It's now. And it's ready to receive assets from anybody. So that's the general time that you need one of those is if you think there's a family member that might leave Joey assets, either during their lifetime or at their passing, but that mom and dad still might be alive. Like a grandparent wanting to leave their grandchild money that would be a standalone special needs trust strategy. Testamentary is when you don't think anybody's going to leave Joey money, but mom and dad will when they pass away. Then you could do a testamentary special needs trust that's already built into your regular revocable trust. And when mom and dad pass away, that special needs trust gets activated, ready to receive the inheritance from mom and dad. And so you normally would want to just ask yourself, has someone expressed an interest to leave Joey money? And if the answer is yes, you'll go standalone. If the answer is no, then you'll go testamentary. So I'll stop there. That was a lot in that little slide. Sandy, you want to maybe go
Yeah.
through the